You guys even see me? I can't see me on the live stream. It looks like a black screen. Hello? Hello? Can you all see me? Viewers? It's weird. No, I didn't call you. Well, maybe the viewers out there can see me. Maybe they cannot. I cannot see myself. Looks like there's audio pickup of some kind, but waiting for confirmation that. Really, you can see me? That's crazy. My screen's not showing myself back. Well, okay, well, whatever then. Y'all can see me, that's good enough. So let's kick it off. Sorry for the delay, folks. All right. Back to work after spring break week that made it so we didn't work. So here we go. All righty, folks. Turn it up a little bit. All right. Today we're doing a Whitlock v. Hilander Foods Incorporated, 720 Northeast District 302, Illinois Appellate Court case from 1999. Get my highlighter. All right. Defendant planned an addition to its grocery store, which would require retaining wall right at the property line. Plaintiff, who owned the adjoining land, gave defendant permission to place workers and equipment on his property during the construction. In September, soon after the construction began, plaintiff noticed that the wall's footings were on his property. Footings are part of the foundation and extend on either side of the wall they support. Plaintiff met the next day with one of the defendant's officers, Castrogiovanni, and said that if the footings were to stay, he would require a lease. Castrogiovanni said they would negotiate a payment for the footings. Plaintiff knew he could have insisted on immediate removal, but he, quote, wanted to be a good neighbor. And he trusted Castrogiovanni's promise of payment. Several communications between the parties and their lawyers followed, but no agreement was reached. In mid-October, plaintiff's lawyer withdrew permission to use plaintiff's property in the construction until the issue of compensation for the footings was resolved. Defendant withdrew its workers and equipment, but continued building from its side of the line. In November, a survey showed that the wall was 3 feet closer to the property line than the wall it replaced. That the wall was on the defendant's property, but that the footings extended 18 inches into plaintiff's property at points below the ground. Castrogiovanni claimed that the footings for the old wall had also encroached. Eventually, he even said that he had seen them before they were torn out and they were in the same place as the footings that were new. The plaintiff said that if either of those things were true, he had not known about it. The lawyers exchanged written offers and counteroffers, and on February 21st, at which point the defendant was offering $10,000 to settle all claims, and plaintiffs were demanding $30,000 for the builder's use of his property, plus $2,000 a year for 20 years for the footings. On March 11th, the plaintiff sued for an injunction ordering the footings be removed from his property. The trial judge granted summary judgment for defendant, holding that the encroachment was not intentional and that the plaintiff had unreasonably delayed in filing his suit. Presiding Judge Bowman delivers the opinion of the court. The trial court erred in concluding that, as a matter of law, the encroachment on plaintiff's property was not intentional. Whether to categorize defendant's encroachment as intentional or unintentional is potentially of crucial significance. Ordinarily, in deciding whether to order a defendant to remove an offending structure, the trial court must balance the hardship to the defendant against the benefit to the plaintiff. If the former is greater than the latter, or as the former is great and the latter slight, the court will ordinarily leave the plaintiff in his remedy in law. However, if the encroachment is deliberate, the court may issue the injunction without considering any relative hardships. Here, the balance of hardships decisively favors the defendant, as a mandatory injunction would require it to undo, at least in large part, a $1.5 million construction project, while the benefits of the plaintiff will be far less clear. However, we believe there is a genuine factual issue of whether the defendant acted deliberately. One knows of a claim one who knows of a claim to land that he possesses to use as his own and proceeds at his peril if he goes forward in the face of protests or warnings from the owner and places a structure on that land. Here, the undisputed fact is the footings encroach upon the plaintiff's property, and that at some point the plaintiff told the defendant that he would not simply accept the encroachment. The evidence suggests that the plaintiff did not protect the encroachment until after the footings were poured. However, this proves little in itself, as the evidence suggests equally that the plaintiff, and perhaps the defendant, did not know in advance that the defendant would encroach on the plaintiff's property at all. A fact finder could infer that when the defendant's agent started to pour the footings, they knew or could easily have learned that they were standing on plaintiff's land when they worked on those. In any event, a mistaken belief by the defendant that it was on the right side of the line would not save it from an injunction if it could be ascertained in the truth by using reasonable care. There is also a factual basis to conclude that soon after plaintiff realized that defendant intended to make permanent use of his property, he protested and put defendant on notice that it proceeded at its peril. After plaintiff made his displeasure known, defendant kept on building the new south wall even though it had not obtained permission to use the property. What the heck? The screen just shut off. What's going on here? I guess we're still going. Okay, cool. My computer screen shut off in the middle of the thing. It's weird. All right. Anyways, there's also facts based to conclude that soon after plaintiff realized the defendant intended to make permanent use of his property. Okay, proceeded as peril. After the plaintiff made his displeasure known, the defendant kept building the new south wall even though it had not obtained permission to use the property. The record provides a basis to find that the defendant knew that it was appropriating the plaintiff's property and pressed ahead anyway. Turning to the second issue, which is latches, will bar relief when, as a result of the plaintiff's unreasonable delay in asserting his right, the defendant has been misled or prejudiced. Whether to apply latches rests with the trial court's decision. There are no fixed rules when latches applies, and the court must examine all the circumstances, including the defendant's conduct. Thus, the court must ask whether the defendant has contributed to the delay of which it complains about, and whether the defendant knew it was violating a right and went ahead anyway in disregarding the consequences. Given these standards, the trial court erred in holding that, as a matter of law, the plaintiff's delay in bringing suit bars it from obtaining the relief. The question turns on factual and equitable issues that ought not to be resolved at the summary judgment stage. Weighing the defendant's favor is that plaintiff did wait 6 months between discovering the existence of the footings and filing suit to have them removed, and that in this meantime, the plaintiff could see the defendant continued to build its addition to the wall at a substantial cost. However, weighing the plaintiff's favor, that there is at least a factual issue of whether the defendant contributed to this delay by incorrectly assuring plaintiff, perhaps in bad faith, that he would be suitably compensated for the permanent encroachment. Also, there's some issue whether the equities favor defendant in that it was aware early on of plaintiff's protests against the encroachment, yet continued a pace of the construction work without obtaining plaintiff's permission to do so. The existence of such a genuine factual issue casts doubt on the defendant's right to invoke the equitable defense doctrine of latches, thus barring on that ground. As did the trial court, the defendant emphasized the evidence that the footings for the new wall simply occupy the same space as those for the old wall, and that it was not clear how plaintiff would be harmed. However, whether two sets of footings are equally intrusive, as well as the circumstances surrounding the existence of the old footings, are not well developed in the factual record before us. Moreover, if plaintiff establishes that the encroachment was deliberate and intentional, he need not show that he will suffer substantial immediate harm from the violation of his property right. The judgment is reversed, remanded, and the case is also remanded to the lower court. All right. Oh, the what was, I was like, my computer screen shut off. Something's wrong with my computer. It's being weird. Like the computer screen like just shut off and went to sleep mode. I had to log back in even though the stream was still going, which has never done that before. Which is weird because I can see myself. I cannot see myself. Like the YouTube live thing is just a black screen to me. So I'm glad y'all can see it live. I'll see it when it's all done, I suppose. Hopefully the framing is right. You can see the banner and everything. Hopefully, who knows? I don't know. I don't know. All right. Move now to Lord Taylor LLC versus White Flint LP. Fourth Circuit case from 2015 before the judges Winston Agee Harris. Pamela Harris. Well, that's funny. I know someone named Pamela Harris. Yep. Wrote the opinion. All right. In 1975, White Flint opened discussions with Lloyd Taylor and Bloomingdale's, a non-party to this case, about development of what could become an indoor shopping mall. Ultimately, Lloyd and Taylor and Bloomingdale agreed to lease land immediately adjacent to the mall and serve as the retail anchor tenants. In exchange, White Flint agreed that it would construct and then maintain a first-class, high-fashion regional shopping center on the mall property. The parties memorialized their understanding on a reciprocal easement agreement, REA, committing White Flint to continued operation of a three-story enclosed mall on that site, and detailing the layout of the mall and its surrounding internal roadways and parking structures. Under REA, most of the site may be used only for retail purposes, and White Flint may build additional structures only with Lord and Taylor's consent. Any changes to the mall, including alterations to its architectural design or appearance, must be approved by Lloyd Taylor. All these conditions are treated by the REA as restrictive covenants that run with the land, creating rights in real property. They remain operative at least through 2042, and Lord Taylor may extend them until 2057 by exercising its financial lease renewal option. This is stupid. It keeps shutting on the screen. It keeps putting my computer on sleep. It bugs me. All right. The mall opened in 1977 and operated smoothly for many years. More recently, however, the mall began to experience a decline in business. In 2012, Bloomingdale's opted not to renew its lease at the mall site. By 2013, 75% of the mall tenants, accounting for at least a third of the mall's space, had left. What's not going anywhere? The stream or this mall? Hang on, Mod. Can you still see me and hear me? Mod. 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 The stream's not going anywhere? What do you mean? Can you see me? Okay, cool. Then, okay, thanks. Okay. In November 2011, Flint released a preliminary plan to redevelop the site, the sketch plan, as part of the Montgomery County broader initiative to redevelop the surrounding area, the sector plan. The sector plan is a massive public-private undertaking. Once complete, it will transform the area, anchored by a station of the Washington Metropolitan Area Subway, into a 430-acre urban center with 14,000 new residential units and 7.5 million square feet of new mixed-use space. Execution of the sector plan is expected to involve $1 billion in new public works and eventually to generate $40 billion in additional tax revenue. White Flint's sketch plan is also ambitious. The sketch plan would transform the mall site into a sort of mixed-use development, increasingly popular across the country, with a 45-acre town center, including 240 apartment units, parks and schools, a hotel, and at least 3 high-rise office buildings. The Lord and Taylor store would remain, but the enclosed mall would be demolished along with portions of the parking lots and internal roadways surrounding Lloyd Taylor. Montgomery County approved the plan in October 2012 and considers it an essential component of the sector plan. Lord Taylor objects to the implementation of the sketch plan and the contemplated redevelopment of the mall site. According to Lord Taylor, what it would promise by White Flint was a first-class shopping center. The town center that White Flint proposes to build around the store is instead, Lloyd and Taylor argues, violates the plain terms of the REA and will negatively affect the store's business, disrupting customer access by destroying internal roads and parking areas and denying the store the benefits of foot traffic from mall customers. Count 2 of Lord and Taylor's complaint seeks a permanent injunction compelling White and Flint to honor the terms of the REA. Specifically, Lord and Taylor asked the court to enjoin White Flint from taking any steps to carry out or construct the redevelopment in a manner consistent with the REA and to require White Flint to abide by its obligations under the REA to operate a first-class, high-fashion regional retail shopping center. The district court assumed that the proposed redevelopment would breach the REA and that Lord and Taylor would be entitled to damages for any harm that resulted. It concluded, however, that injunctive relief would be infeasible under the circumstances. Because of physical changes to the site, most notably the demolition of the Bloomingdale's store, and what was then a 75% vacancy rate, the court reasoned that an injunction requiring White Flint to operate a first-class shopping center contemplated by the REA would require the court to supervise the rebuilding and bringing tenants back into the mall, a task the court deemed outside of its competence. For me to enter into this case and try to enjoin an ongoing development project like this is just not feasible, end quote from the court. Part 3A. The parties agree, as do we, that Maryland's substantive law applies in this diversity action and governs Lord and Taylor's claim for a permanent injunction. According to Lord and Taylor, however, the district court took a different approach and relied instead on the federal law standard for injunctions in denying relief. We do not read the record that way. We take the district court at its word and have no reason to doubt that it properly identified Maryland's substantive law as controlling. Lord and Taylor argues in the alternative that if the district court applied Maryland law, then it misapplied it badly, relying on factors that have no place in the analysis under Maryland precedent. Maryland law, Lord and Taylor contends, strongly favors injunctive relief for breaches of restrictive covenants, so strongly that injunctions are granted almost as a matter of course and regardless of factors like public interest, the availability of monetary damages to compensate for such a breach. If White Flint's proposed redevelopment would violate the REA and the district court assumed as much for the purpose of summary judgment, then according to Lord and Taylor, there was virtually nothing left for the court to do but enjoin the breach of the contract. We disagree. It is true that an injunction typically is an appropriate remedy for a breach of a restrictive covenant under Maryland law, but injunctive relief is not automatic, and presumption in favor does not displace a trial court's traditional discretion when it sits in equity. See Roper v. Camuso, a 2003 case. One thing that Maryland law makes perfectly clear is that the trial courts may take account of feasibility concerns, those relied on by the district court here in considering injunctive relief for a breach of a restrictive covenant. In this context, as in others, trial courts retain discretion to deny specific performance or injunctive relief. Maryland case law does not distinguish between the two for this purposes. Where enforcement would be unreasonably difficult or require long continuing supervision by the court, see Edelson Real Company versus Bauernschnapp, a 1948 case. So, for instance, an injunction may be denied as infeasible if it would compel parties to continue a commercial relationship or to require court to closely monitor the caliber of either party's performance. Got you, chat. Thank you. Performance. In its endeavor to, indeed, because such affirmative injunctions are difficult to draft clearly and even harder to enforce, Maryland courts typically will issue them only when there is no other relief possible. And the inquiry into feasibility is itself wide-ranging and equitable in nature, with courts instructed to consider broadly the advantages to be gained from the injunctive relief as well as the harm to be suffered if an injunction is denied as infeasible. Whether the district court properly exercised its discretion in determining the injunctive relief would be infeasible in this case is a separate question, which we address in turn. The point here is simply that Maryland law did not require the district court to turn a blind eye to feasibility and related equitable concerns. On the contrary, Maryland law clearly authorizes the district court to go beyond the state law presumption in favor of injunctive relief to consider feasibility of what it was being asked to do. Right. Next we have part B. It's a little long, we'll be all right. All right. I'm going to get through this. Even on this account of the law, Lord and Taylor argues the district court erred because the injunctive relief it seeks would in fact be entirely feasible. On this claim, the district court's determination is highly deferential. When a district court's decision rests on evaluation of equitable considerations or other traditionally discretionary factors, we generally apply an abuse of discretion standard. That deferential approach makes perfect sense when it comes to the feasibility of equitable relief. The district court is better positioned than we are to weigh the costs and benefits of injunctive relief, and in particular to assess the practical difficulties of enforcement of any particular injunction. Yeah, Lord and Taylor's is in the store, yeah, and Bloomingdale's is in the store. This is in the Maryland, D.C. area. Like Lord and Taylor's the store, and Bloomingdale's the store are the ones who are arguing about this shopping mall. Yes, yes. Like the district court, we must take account of the practical realities of the situation. At the time of the district court's decision in December 2013, Bloomingdale's had declined to renew its lease, and the building it occupied had already been demolished. Much of the mall itself was vacant, and according to Lord and Taylor's, many of the remaining tenants were on short-term leases that were due to expire in early 2014. Restoring the mall to its former glory, as Lord and Taylor requested in count 2 of its complaint, would have required more than a negative prohibition on the site's redevelopment. It should have necessitated an affirmative injunction ordering White Flint to transform the now fading mall back into a first-class, high-fashion regional retail shopping center, the kind of order that is so hard to draft with specificity, and then to enforce that, Maryland courts generally will grant it only as an option of very last resort. In this case, affirmative injunctive relief would have been even more impractical than usual, thanks to the highly detailed provisions of the REA. And in order that White Flint abide by its obligations under the REA as sought by Lord and Taylor would also require a judicial oversight of the compliance with a myriad of REA conditions that control every facet of the mall's operations, from the distribution of parking and interior access roads to the placement of entrances to the design of the various retail stores and restaurants that populate the mall. And once it had ascertained that the mall's operations were again compliant with every provision of REA, the district court's job still would not be done. It would have to ensure that the mall remained in the compliance for the duration of the REA, at least until 2042, and potentially for over 40 years. Such long-term, ongoing supervision eventually would entangle the district court in every aspect of the mall's daily operations, with any potential violation of the REA specifications becoming fair game for subsequent contempt proceedings. In the case is Lord and Taylor's side to argue that this is all would be perfectly feasible, suggest just to us just the opposite. The scale and complexity of the mall's operations, spread over 45 acres and potentially involving dozens of new contemporaries as the mall repopulates, and the duration of the proposed injunction having no parallel in any Maryland case law, the injunction sought here would be nothing like the one that prohibits operations of a single nearby competitor, citing from Redner's Markets v. Japotowne 2013 case, which enjoined the operations of a rival grocery store in the same strip mall. Nor does it resolve a single dispute over a misused office space, citing City of Bowie versus MIE Properties Incorporated 2007 cases, which enjoined the operation of a dance studio. By comparison, Maryland courts have found injunctive relief infeasible under circumstances far more streamlined and straightforward than these, involving purely bilateral commercial relations. See Leo M. Storch, LP, at page 414, which refused to order a tenant to reoccupy a leased retail space upon feasibility grounds. We can find no Maryland precedent, and Lord and Taylor provides none, even suggesting that it would be feasible for the court to craft and enforce an order directing White Flint to reboot and then maintain a first-class, high-fashion retail shopping center consistent with the REA's detailed specifications through the year 2057. At oral argument, Lord and Taylor refined its position, suggesting that it would be satisfied with a more limited, negative injunction that simply prohibited White Flint from moving ahead with the destruction of the mall and its adjacent parking areas. That is essentially the same proposal Lord and Taylor offered to the district court when it moved there for a stay of the pending appeal. The district court rejected this version of the motion and the proposed relief as well, deeming it unrealistic to require White Flint to maintain the status quo of a mostly empty mall with a demolished anchor store on one side. In effect, the district court held redevelopment had passed the point of no return. Again, we must attend to the realities of the situation facing the district court. A negative junction, as the court understood, would freeze in place a vacant and partially demolished mall, tantamount to a judicially mandated blight on the entire urban area. That outcome would serve neither party in the dispute, let alone the interest of the general public. Indeed, it was so patently unworkable that Lloyd and Taylor defends it not on its own terms, but as a form of leverage that might encourage White Flint to resume mall operations consistent with an REA. But the district court cannot simply assume a best case scenario and must instead contend with the very real possibility that a negative injunction would produce nothing but an empty and unusable 45-acre mall in the heart of Montgomery County's redevelopment project. Moreover, even if a negative injunction did send White Flint back to the drawing board and eventually to the negotiation table, feasibility concerns would remain. Such should the parties dispute whether any White Flint proposal to repopulate and restore the mall lived up to the detailed specifications of the REA or produced a sufficiently first-class and sufficiently high-fashion shopping center, the district court would find itself inserted once again into the thick of an ongoing and complex commercial relationship. And any effect to resolve that dispute by the way of injunctive relief would raise precisely the feasibility issues that have already been described. Taken together, these concerns are more than enough to persuade us that the district court did not commit a clear error of judgment in finding that adjunctive relief would be infeasible. Continuous judicial supervision of commercial relationships on this scale may place a particular strain on a district court, and the decision to refuse such intervention goes to the heartland of the court's discretion to manage its own affairs. Whereas here, the district court follows applicable state law and reasonably exercises its discretion in denying injunctive relief as infeasible, we have no grounds to second guess its discretion. Affirmed. Well, that's all the remedies for tonight. We still have conflicts coming up, so stand by, fangirls.